Remember Johnny Cash's I Walk the Line? You should all know that one. I even know that one. Walking the thin line between zealous advocacy and punishable misconduct can at times present a lot of challenges for in-house and outside counsel both. New York lawyer and Nixon Peabody attorney Joe Ortego is going to take us down that line and give us some examples of learning from the experience of others who may or may not have walked the line appropriately. So please welcome our last final speaker of the day, Joe Ortego.
We all like to win. None of us like to lose, and in litigation, we want to win. We're like little children playing board games and sports. We want to win. But let's be realistic about why we want to win. There is tremendous pressure on us from our clients, both in-house lawyers and outside counsel, to win. There is tremendous business pressures on all of us to win, both in-house counsel and outside counsel. Think what happens when you lose a case. Losing is never good for business development for the private firm, and certainly not good for the in-house counsel that sits next to the CEO. Not good. And then there's our egos. And when we get older and grayer, we just don't like to lose because we're not playing sports anymore. We're not doing anything, and maybe this is the game that we could win at. And you know, when I was a prosecutor in New York, everything was black and white to me. Now that I am gray, everything is gray to me. Temptations are everywhere for us as advocates to cross the line and do something that we will regret. And reputation is like toothpaste. Once it comes out of the tube, it never goes back. So let's walk the thin gray line and see what people have done when the line of zealous advocacy has crossed with unethical conduct and improper conduct. And let's learn from the mistakes of others. And if you think it's so easy, it is not. The area and the business pressures make it gray. First area we should talk about is where we've gotten ourselves in trouble, both lawyers, in-house and outside counsel, is in whether we pay witnesses for their testimony. I know it sounds simplistic, but it's not so simplistic. How we prep our witnesses for strategy and what we do when we prep these witnesses. What do we do when our witness testifies falsely, particularly when it's the client? What do we do when we take a deposition? Lawyers get themselves in trouble there. And what do we do when we defend a deposition? How do we get ourselves in trouble there? And then the best of it all is when we're in-house counsel and we get called as a witness. And we're in a bind even bigger than ever. So let's talk about witnesses and some of the problems that people have had. Can you pay witnesses? Oh, of course, not me. I wouldn't pay a witness. Let's give you a little hypothetical. You have an important case to the company. Former employee gets canned by the company. It's got critical witness. You call that witness in, I need you to testify in our case. We're gonna come and testify. Oh, no, I'm not. You canned me, threw me out on the street, and I hate your guts. I'm not coming. Well, I'll subpoena you. Oh, yeah, you'll subpoena them, all right, and I'll give you some very truthful testimony about your company. What do? You want to entice that person. Well, there's one enticement I found kind of interesting. There was an attorney in an antitrust case who had some very valuable information for that person in that antitrust case. Called up the in-house counsel of that case and said, listen, I've got some great information for you. It's going to take away from my cases. I want $500,000 up front, $5,000 a month, and I will work with you on this case and I will make you a winner. Can you do that? This lawyer apparently thought he could. And he is now in federal prison serving 6 months in jail. A very good business opportunity. What can you do with witnesses? Let's talk about that. What can you do? You can pay for their travel. You can pay for their prep time. You can pay for their testimony time along it's reasonable, say you're out of work. But you cannot pay for actual testimony. And where have people gotten themselves in trouble? You shall not pay for the inducement to induce someone to testify. So what's an inducement? How much money is an inducement? Oh, Mr. Smith, I know you were on the production line and you were making minimum wage. I think we're going to pay you $2,000 a day because I think you're very, very valuable. No good. And it all goes into the balancing of the money. Fact witnesses preparation. Okay, you think it's easy? CEO comes into the company. CEO is also a lawyer. In-house and outside counsel is sitting down. I'm a very, very busy woman. I don't really have time for this. Just tell me the elements of the complaint, give me those jury instructions, and tell me what I got to say to win, and let's get the hell out of here. I'm ready to go. Can you do that? The answer is probably surprisingly yes. And you can do that. And it's kind of frightening it sometimes. There's nothing wrong with doing that. What you cannot do as in-house and outside lawyers is you cannot engage in illegal conduct. You cannot assist in illegal conduct. You cannot falsify evidence. And I know, it sounds very blatant. You know how many lawyers you see get caught falsifying evidence? It's amazing. And you can't do that. But you have tremendous flexibility. You can educate your witness. And you can invite your witness to tell the truth if you think they're not telling the truth. And then you could be kind of persuasive by telling them that, I call it, you're going to get caught. So let's try something different. So you advise them on how to do that. And you can reveal to them how they're going to be cross-examined. You can prepare them, you can rehearse them, and you can give them the elements of proof, and you can get them ready to testify properly. There is nothing wrong with that. Okay, get into the hypothetical, false testimony. The heir apparent to your company, who's about to become your employer and CEO, wants to make a name for himself this time, and he is very interested in doing so. And you're sitting down there and you're listening to his story because he wants to be very helpful in your lawsuit, and you're saying, boy, this is a bunch of BS. I don't buy a word of it. What do? Well, it's the most important client to the outside counsel's firm. He doesn't want to alienate that person. And the in-house counsel's sitting there hoping they're going to be employed by the new CEO. What do when you know the CEO is going to lie or falsify? This I found kind of interesting. A lawyer's only duty is when you know the testimony is false, then you can't use it. And then you can't use it. But then that's a fine line because now things are gray again. Well, I like Mr. Smith as the former heir apparent, just a good person. I doubt he's lying. I probably just don't know. You really don't have to dig that deep, unfortunately. But if you find out that that person is lying, you are now on the hook. And there's plenty of lawyers that have offered false testimony that have gotten themselves in trouble. And when you figure out that it's a falsehood, you've got to resolve that falsehood. Well, I give you some practical advice on this, and what I have done in the past is I use you're going to get caught routine. And we can win this case without you lying. But you've got to do it in a diplomatic way, or your accounts receivables will not be paid, and you will no longer be billing any money to that client. I think that's kind of difficult at times. You got to protect yourself as a lawyer, both in-house and outside counsel. You cannot sit back and let someone testify falsely. I've seen lawyer after lawyer after lawyer, if you read these disciplinary opinions, where the witness who testified falsely is never indicted for perjury or punished, but the lawyer is disbarred or suspended. We have a higher standard for us as lawyers. We need to preserve the profession. We need to have lawyers be known as honest and truthful, and you can't get away with that. But these business situations in today's world are very difficult. Okay, your CEO now comes, and the CEO is going to start lying. What do you do now? It's very important. But the first thing you've got to do is try to resolve the lie. We talked a little about that. Or the false testimony, and explain to why that doesn't work. And if you find out later, you've got a duty to disclose it to the court that the witness testified falsely, which is good, which is really good for you. And now there's the safe harbor position, which I find interesting, is you seek withdrawal of the case. And when you seek withdrawal of the case, some courts will require you to say that you could not support the witness's testimony and you need to withdraw. It's called the safe harbor provision. So basically, without breaking privilege, you've got to go to the court, tell the court your client is lying, and you need to get out. Very, very successful business tactic, but being disbarred is also another unsuccessful business tactic. And getting a job someplace else has always been an unsuccessful business tactic. I've watched when business folks have been indicted or when they get in trouble, it's always the lawyer or the in-house lawyer that suffers the most because they should have done something about that. They should have figured it out. So when you think twice about this and you get a little nervous of doing the right thing is for you to do the right thing. Witness preparation, defending a deposition. This I found also interesting, and it varies from jurisdiction to jurisdiction. Your client, who you represent, is starting to get killed at the deposition. You kick him in the leg, you tell him he needs to go to the bathroom, he doesn't get it. You said, you need to get out. So then you start conferring with that witness in the hallway, and you tell the witness you're screwing up. Can you do that in the middle of a direct deposition? Well, some states, including Pennsylvania now, are holding that you cannot do that. That once the testimony begins at a deposition, it constitutes cross-examination, and you're under oath under cross-examination, and you cannot counsel the witness while it was under that time, and it's improper. And lawyers have been sanctioned in certain states for this. There's a split about this, but you cannot do that in a lot of states. And what's the punishment for that? The punishment is that the conversation that you heard in the hallway, in addition to being sanctioned, is no longer privileged because you had an improper conversation, and everything in that conversation needs to be revealed by the lawyer. Now you've waived privilege. I find these kind of interesting because I didn't know that, and I will say it sometimes I am not completely innocent of depositions because I want to win and I want to protect my client. It's a difficult thing to do. Taking depositions or trial testimony, a very interesting case. A lawyer is cross-examining at trial, this would be the same for a deposition, is cross-examining a witness, an adverse witness. Great cross-examination, things are going really well, and the witness comes to a critical question and answers it exactly the way you didn't want the witness to answer. The lawyer gets a little upset, gets kind of nervous, what am I going to do? Reaches under the podium, pulls out a batch of cassette tapes, starts fingering through the cassette tapes, and says, would you like to reconsider that answer, sir? Pulls out a tape nice and slowly. Okay, I give up, maybe I don't remember. Well, the problem was the tapes were blank. There was nothing in those tapes. It was a shill, it was improper. That particular lawyer was suspended in Cincinnati for 6 months for bluffing at a deposition. You're not permitted to do misrepresentations to witnesses. You can't make believe you have a document you do not have. You can't act that there's evidence that you have that doesn't exist. Sounds kind of simple, but I challenge those of us who have been in court that have not tried to do that. In-house counsel as a witness. One of the most shocking things for me trying a case for a large international company, sitting there and being served with a subpoena for the in-house counsel witness that was sitting next to me during the entire trial. I turned to the associate who's in the audience and I said, you've got a problem, you better fix this. Well, can in-house counsel be called as a witness? Can you be called as a witness? The answer is yes. You can be called as a witness. And in many companies, in-house counsel is wearing different hats. You're wearing a hat as a business person, you're wearing a hat as the lawyer, you're participating in conversations with other people that aren't privileged. So what are you doing? You don't think about it at the time, and now you've opened yourself up in a lot of different ways because were you acting as a business person? So these cases are even more interesting because they have another effect. Let's say you're the in-house counsel or even the outside counsel that has access to this information. And now you're called as a witness at a deposition. You're no longer trial counsel. You've just disqualified yourself because you're now a witness. And that's a tactic that I've seen in a lot of cases in which the lawyer has been called as a witness or been tempted to call her a witness during a deposition so that that lawyer will not try your case. And that would include the in-house counsel who is joint in partnering the trial. Second Circuit has dealt with this in many different ways. They have a whole standard on what you can do. The Second Circuit says you need to look at, to depose a lawyer, you got to look at the need on whether or not the in-house counsel or outside counsel needs to be deposed, what the lawyer's role was in connection. the risk of endangering or encountering privilege, and the extent of other discovery that's available to the other side that doesn't involve using the lawyer. It's kind of difficult, and it's a fact-intensive thing. So I just want you to think about getting an unfriendly judge to your client and wondering what's going to happen in that fact-intensive analysis. That's one of the other areas that people get themselves in trouble, and it's unnerving, and it's quite an embarrassing thing. What other ethical issues that I like to talk about? One is what happens during settlement negotiations? What happens during judicial manipulation? What happens in litigation pleadings? And I'll be quick on those. Settlement negotiations. How much puffery is allowed when you're in settlement negotiations? Well, any of those who practice in New York State know that the judge will call you in. How much coverage do you have? How much authority do you have? And anyone who tells the truth is probably making a mistake because you're going to be playing that plus 10. So you think about that and you sit there and the judge tells you that, but what you can't do is you can't make false statements. You can't fail to disclose material facts. So in a particular case, 2 cases I looked at of interest, a lawyer says, you know, if we negotiate this and pay this out, we won't be able to do X. It'll cost the company too much. We are unable to do that. That was false. One that was even more interesting was a medical malpractice case. All the coverage we have is X, and that's all we have, and you can have it all. That's not true. They had a lot more coverage. Not only was that award and settlement affirmed, the family was allowed to seek damages for that false and misrepresentation. The bottom line is you can't puff around and go into the gutter with everybody else during settlement discussions and start lying and misrepresenting. Once you open your mouth, you have to tell the truth, or you've got to be quiet. It's probably the safest thing to do. But you cannot mislead the judge. You cannot mislead your adversary. You cannot make false statements. You can't say, well, I got some good documents that are really going to help me and it's going to refute your position. If you don't have those documents, it's unethical to say that. If you don't have certain testimony that doesn't exist, it's unethical to say that. You cannot do those things. You cannot lie on, which is a kind of a simple thing, but when you're in the heat of battle and you feel you're being taken advantage of, we tend to bend the rules. The final thing I wanted to talk about, which I thought was kind of interesting, and it's sort of a new thing in New York. I've been representing clients in a big split up of a law firm, and it's gotten kind of ugly. So one of the lawyers decided that they were going to file a defamation complaint. Defamation complaint against the other lawyer. And, you know, for bad things saying about the practice of that particular lawyer and the honesty of that particular lawyer. The pleading was 150 pages long, and it had approximately 200 exhibits. And in that pleading was, we have pleading immunity in New York. Whatever you put in a pleading, you can't be sued for defamation. In this pleading had a lot of interesting things, and I found them very interesting to read. The client's sexual escapades, pictures of his illegitimate children, the prostitutes they saw, everything that would destroy this particular lawyer. And of course, I'm sure his spouse enjoyed reading it. Everything was in there, had total no relevance to the defamation claim, and they're claiming pleading immunity. What's happening now is you cannot do that in New York State. Not only is it unethical and improper, you can get sanctioned for it. But for years, lawyers would do things to particular corporate clients, put in about how terrible the company is, how evil the company is, and in an unrelated matter, they did this terrible thing. You cannot do that anymore. The courts have now sort of compromised the immunity pleading rule in New York State. There's a lot of things that can go wrong at trial, and I only give this piece of advice. You know what's right and wrong, and when the pressures come for you to do the wrong thing and cross that line and not walk that line, it's easier in the long run to your pocketbook, your reputation, and your life to be a decent person and a good lawyer. I wish you luck.